invited to participate with you all, and my connection here is that through the environmental clinic, we represent a couple of Indian tribes and do some, we dabble, I would say we dabble, and then when I need more help, I come to Karen for trying to really understand Indian law. So I'm excited to have our panelists here today, and because we're getting started late, I'm going to kind of skip long introductions. There are bios in the material, so you can all take a look at that. But so we can launch right into it. And we're going to start, I think, with Professor Bethany Berger, who is the Thomas F. Gallivan Jr. Professor of Law at the University of Connecticut Law School. And she's going to lead us off with talking about jurisprudence in the Supreme Court right now, and focusing on the adoption issue that's very hot topic right now.
Yeah. So, as you can see from the title of this is not a kind of happy way to start the day. I think a lot of us try to avoid looking at the cases as a whole because, although we really watch as the cases come down, and the second as they come down, each one often feels a little bit like a big punch, and you kind of reel back, you regain your balance, and then you wait for the bruise to fade. So focusing them all together is pretty depressing. And so one person that did do this was David Gittis, who great figure in federal Indian law, former dean of the University of Colorado, very sadly died of pancreatic cancer in 2011. And in a 2001 article, he said he looked at all cases decided by the Rehnquist court up to that point. And he found that while it'd been about 58% wins in the Berger court, on the Rehnquist court then, tribes were winning only 22% of the time. And that was worse, he said, than the rate of convicted criminals seeking to get their convictions reversed by the Supreme Court. So pretty bad. And his theory was that because Indian law cases bring together concerns that the majority of the court had about that point about colorblind justice, about state rights, about mainstream values. And as you'll see, well, I think there's something there. There's also, it doesn't explain the whole story. So what's the response from Indian country? The Tribal Supreme Court Project, the National Congress of American Indians and Native Americans Rights Fund, got together with a lot of tribal leaders and professors and lawyers from across Indian country to try to coordinate advocacy in the Supreme Court. Big thing, try to keep cases out of the Supreme Court. If they got there, make sure that the best case possible was brought forward. In particular, make sure that the arguments were made were ones that could be appreciated by people that had a colorblind image of racial justice, that were concerned about state rights, that favored mainstream values. And by mainstream values, Kristen, I think, might talk about this more, but that means Christian prayer in schools is good, eagle feathers not. And at least when I was looking at this in 2004, 2005, this looked pretty good. Between 2002 and September 2005, we had 3 wins and 2 losses. And one of those wins was U.S. v. Lehrer in 2004, which was a pretty significant case, substantially led to the Violence Against Women's Act, affirmation of tribal jurisdiction over non-Indians committing domestic violence in Indian country. And then we get to the Roberts Court. So Roberts came on the court in September 2005, and this is a picture from drawn of Native observers in the recent adopted couple versus baby girl argument. And so first we get Blackman case diminishing immunity from state taxing jurisdiction for purchases made by non-Indians from tribal businesses on reservations. Plains Commerce Bank, limiting tribal jurisdiction over non-members. Carcieri v. Salazar, reversing decades of federal assumptions to reverse the ability of certain tribes to take land into trust. U.S. v. Nomination, which really was a bit of a redo of a case that had gone before, but limited the ability of tribes to sue the federal government for mismanaging tribal property. Hawaii v. Office of Hawaiian Affairs, which allowed the state to reverse lower court decisions, allowing the state to sell land that was held in trust for Native Hawaiians. U.S. v. Hickory Apache Nation, which limited the application of common law trust responsibilities to claims by Indian tribes for mismanagement of tribal property. U.S. v. Tohono O'odham Nation, which procedural limitation on tribal ability to bring trust claims. And I was going to ask you how to pronounce this quickly before I said it, but Machiavenachshiwish Band of Potawatomi Indians.
It's pronounced Gun Lake Band.
Yes, I was going to say that, but I thought I should take it easy out. I'm going to call it Pacha from now on. And finally, what I'm going to talk about a bit more, adoptive couple versus baby girl. So we've got 9 losses, and what do we have on the win side? Salazar v. Ramanathan chapter, and nothing else. So that's 10% win rate. And Salazar is basically a case saying that when the federal government promises a tribe under a contract, makes a contract with the tribe, we are going to pay you X amount for managing governmental services on the reservation, they have to pay that amount. Not a real tough decision. And so how well does this fit into Gittis' framework? Certainly there are cases that are about, that you could say are about colorblind justice or state rights, but a lot of them really don't fit there. So Hickory Apache Nation, for example. This is a case where tribes are suing the federal government for mismanagement of tribal property held in trust, and they want to see the records about the management of the property. And the federal government says, oh, no, you can't see the records about this because you're suing us and we're your attorneys, attorney-client privilege. Well, under common law trust responsibility, you can't claim attorney-client privilege to refuse to give over your records to the trust beneficiary. The Supreme Court looks at this and says, yeah, but that doesn't apply in Indian cases. Look at Pachak, the Gun Lake Band case, and that's a case where the court actually restricts federal sovereign immunity, allowing individuals to sue years after the fact to challenge federal decisions to take land into trust. These, just don't fit. And I'm going to talk a bit more about really ugly, the adopted couple versus baby girl. You can look at any of these cases, and a lot of these cases, not all of them, a lot of them say they're really ugly, but this one, I think, hit a lot of us hard because it involved a little 4-year-old girl, in the end, being taken away from her birth father she'd lived with for the last 2 years, without even a hearing about whether that was in her best interest, to go back to the couple that wanted to adopt her, which she had lived with for the first 2 years of her life, basically because of an illegal placement that was secret from the father. And just to, this got a lot of press because the adopted couple had a public relations firm, and the attorney for the guardian ad litem of the Supreme Court was Paul Clement, who Supreme Court superstar and basically the voice of every case for the more conservative wing version of the law. So he he litigated the challenge to gay marriage. He litigated the challenge to adopt the Affordable Care Act. He litigated, I think, the challenge to the Voting Rights Act. He litigated challenges to affirmative action as well. A lot of those cases he lost. One, adopted couple versus baby girl. And so, just some facts. He's been, father's been presented as a deadbeat dad. In fact, the mother and the father were engaged when she first became pregnant. He begged her to move the wedding forward so that he could support them better. He was active military. He was living on the base that they got married. She lived there as well with her 2 children from another marriage. She refused. She eventually broke off all contact with him, wouldn't respond to his or his parents' phone calls, wouldn't come to the door when he went to try to see her, checked herself into the hospital secretly under a different name. By the time she broke off the engagement, she had already begun contacting the adoption agency, possibly begun speaking to the Cocobiancos, the adoptive couple. Though there's supposed to be notice to the Indian tribe before placing a child, they misspelled his name for the wrong year of his birth, so even though she clearly knew it, so that there was no way they could figure out that this child was in fact eligible for enrollment in the Cherokee Nation. Didn't tell the father anything about this until 4 months after the placement with the adoptive couple when he was about to be deployed to Iraq. He immediately went back to his base, contacted a JAG attorney, and 3 days later filed for custody. And thinking about what's best interest, first the trial court found it was going to be in the best interest for the child to stay with the father. 18 of the leading child welfare organizations in the country, everybody that cares most about these issues, filed an amicus brief saying following the procedures here was in the best interest not just of Indian children, but of all children, making sure that there is a stable and valid consent before adoption by biological fathers. I'm not going to go into the construction of the statutes. You can see it's very small type there. But it was really a bizarre construction of the statute in the Supreme Court. Basically, the court said, although he's a father, although he's got rights to notice, he's got rights to intervene, he's got rights to review all the records before his parental rights are terminated, he didn't have any right to make any substantive objection to that termination of parental rights. Also said that despite the placement preferences under the Indian Child Welfare Act, which they first have to look to the child's extended family, and then to other members of the child's tribe, and then to other Indian families, those preferences didn't apply because this birth father didn't formally apply to adopt his own child before the case by the adoptive parent was filed. So you might say this is a case about colorblind justice. This was really the meme, the mantra of Paul Clement and then the Supreme Court. This is the first line of the opinion. This case is about a little girl who is classified as an Indian. She's 1.2%, 256 Cherokee. First line of the Supreme Court opinion said twice more in opinion. First line of his amicus brief, repeated 5 times. This was repeated 3 times in Clement's oral argument. And when Charles Rothwell stood up to speak for the birth father, basically where half of his argument was taken up with responding to, like, what's going on here with this 1.2%? The reality, as probably a lot of you know, Veronica's percentage of Cherokee heritage had nothing to do with whether it will apply here. For it to apply, you have to be the biological child of a member and be eligible for enrollment itself. Cherokee Nation says you have to show descent from somebody on the rolls created around 1906. They clearly had that. And in fact, we know those rolls are bad. They don't say what, they don't include what your heritage is actually. The family believed that they had much more heritage. Actually, the birth mother that the adopted couple sought to characterize as her race was Hispanic, so the child was half Hispanic. I don't know, I mean, half Hispanic. But she claimed to have Cherokee heritage as well. But like a lot of people, that her Cherokee heritage wasn't recorded on the official rolls. And taking a look at the colloquy in this case, this was not, oh, color blindness, race matters. It's, you're not racial enough to count. So this is Justice Roberts. Is there a threshold at all before you can call under the statute a child, an Indian child? 3,256. And what if the tribe, what if you had a tribe with 0% blood requirement? They're open for, people who want to apply, who think culturally they're a Cherokee, or any number of fundamentally accepted wonder, is 3,256 close to zero? I mean, that's a question in terms of, to me, and to Justice Alito. But what if the tribe makes eligibility available for anybody who is a result of a DNA test and establish any Indian ancestry, no matter how slight? They're not saying this matters because of race or heritage. They are saying you don't count as Indian because you're not Indian enough. And what is this? This is not colorblind justice. This is a very old thing. Very old determination that the way to deal with settler colonialism is to absorb Native people, say they're not Native people anymore. So America has been celebrating intermarriage and supposed dilution of Indianness since the very beginning. So this is a painting of the conversion of Pocahontas in 1839 and hung in the Capitol Rotunda. We've been celebrating this forever because if there are no Indian people, there is no Indian problem. And that's what this case is really about. And in fact, if you look at the birth father's family, this was a family that was culturally and politically Cherokee in every way. So he's a member of the Wolf Clan. Very important thing for Cherokee belonging, not necessary, but an important thing, where he lived. He lived at the edge of the Cherokee jurisdictional area. He lived in Indian country. These are some of the, I think it's not grape dumplings, it's, I think, buckskin bread. But they talked about all the traditional foods they cooked in their home. He didn't vote in the Cherokee elections, but his father did. They went to stomp dances. So basically saying, even in every way you're Cherokee, you're not racially Indian enough to be Cherokee. So, okay, this is just very depressing. Is there any good? You gotta look away from the court sometimes. And there are all kinds of examples of great stuff happening in Indian country. So if we look, a study done of the contrast between the 1990 and 2000 census, Native people, both gaming and non-gaming on reservations, are gaining, making meaningful increases in standard of living, both relative poverty and income and employment to non-Indians, also in education, in, I think the one thing that they weren't gaining in, or maybe a couple, was like housing overcrowding. Part of the reason they're not gaining in housing overcrowding is people are actually moving back to reservations. People are leaving, non-Indians are leaving the Plains states, for example. Native people are moving back because there's actually jobs there now. There's meaningful jobs there. So just some more recent things, something Chris has written about. 2010, he agrees to support the UN Declaration of the Rights of Indigenous Peoples. Very significant document. 2010, we also have the Tribal Law and Order Act. Other people can talk a lot more about this, which mandates increased federal and state coordination with tribes and increases tribal sentencing power. 2013, VAWA extends tribal jurisdiction over non-Indian abusers continuously since the 1950s. Native people or communities are increasingly in the position to shape their destinies. So, top left, this is the private consultation meeting between President Obama and tribal leaders. Bottom right, consultation meeting of the Administration for Children and Families with tribal leaders. There's Kathleen Sebelius in the corner. Top right, this is sturgeon restoration. The St. Regis Mohawk, like a lot of tribes, are actively involved in managing and restoring this important natural resource. Bottom left, this is a graduate from the Northwest Indian College. And just thinking about this day. So the people that I started teaching Indian law with, people like Matthew, like Kristen, like Angela, like Bob, like Stacy Leeds, who's now a dean at University of Arkansas, majority of them are Native people. That is something we would not have seen 10 years ago. And the rest of us, I think, Sarah Krakoff, Ezra Rosser, me, we all worked or grew up on the Navajo Nation. I don't know what that means. But that is an amazing thing. So we need to keep winning some cases in the Supreme Court. If we lost U.S. v. Lara, we probably wouldn't have gotten the NALSA change, the VAWA change. If we didn't have the level of tribal jurisdiction and immunity from state jurisdiction we have, if we didn't have the affirmations of tribal self-government we have in the Supreme Court, we wouldn't have had these statutory changes. We wouldn't have the freedom for tribes to control their destinies, to make the kind of contracts they are making now. But that's not the whole story, so we not need to move forward.
Thank you, Bethany. Well, I think we're going to get more depressed before we get. So next we're going to hear from Matthew Fletcher, who's a professor of law at the Michigan State University College of Law, and he's the director of the Indigenous Law and Policy Center there, and he's going to speak with us about bullshit and tribal clients.
That's right. Thank you very much. So today I'm going to draw upon some of my experiences before I became an academic. I worked exclusively in-house for Indian tribes, and I've been watching what's been going on in a case called Michigan versus Bay Mills Indian Community, and I think that there's some useful things we can learn from that case. So the long title of my paper is The Role of In-House Tribal Counsel in Supreme Court Litigation, but I just shortened that to Bullshit and the Tribal Client. Let's start with a few baseline truths, and you can put truths in scare quotes here because these things may change over time. Number one, and I think Bethany expressed this pretty well, is tribal interests are disfavored at the Supreme Court. And this goes beyond wins and losses. This goes to the structure of the Constitution, puts tribes way down at the bottom compared to the federal government and states. And I think there is a cultural disadvantage as well for tribes in that most elites who practice law in D.C. and the Supreme Court know little enough about Indian law and are not particularly impressed with tribal interests for a lot of different reasons. So the second baseline truth is that repeat players in Supreme Court litigation do a lot better than those who are not repeat players. And there are few, if any, tribes who could qualify as a repeat player. And a repeat player does well because they know how to litigate a case, the court becomes familiar with them, they have resources and political power to put forth a good position, a good face at the Supreme Court. Very few tribes have that ability. Perhaps the only one that I'm aware of that would even count is the Navajo Nation, and I only even consider them because they're the last one to actually win a case. So there are a few repeat players, and that's a big deal. Number three, there is a Supreme Court bar of Supreme Court specialists. By definition, the Supreme Court specialists are repeat players. Now, they're just attorneys. They're not actually the clients. But tribes, I think, because of the Supreme Court project for the past 10, 12 years or so, have been pretty successful in retaining members of the Supreme Court bar to argue a lot of these cases in the Supreme Court. So they're sort of borrowing somebody else's repeat player status, and that can be helpful as well. Of course, tribal people who are interests who oppose tribes do the same thing, so it's a bit of a wash. And winning just one case in the last 10 years, for example, is not, or the last eight years or so, is not indicative of success there. And I guess the last baseline truth I want to start with is bullshit. Bullshit is a form of deception. And I borrow heavily from Harry Frankfurt, who wrote the book on bullshit several years ago, based on a talk he'd given in the 80s. And I just wanted to give you a quick definition of that. And we can talk more about that. I'm not a philosopher, but I'm borrowing heavily from this philosopher. And bullshit is deception, but it is not lying. Liars care very much about the truth. That's why they are telling you the exact opposite of the truth in the form of lying. A bullshitter doesn't care what the truth is. The bullshitter is only interested in getting you to do something that the bullshitter wants done. So for example, a politician, perfect bullshitter. A politician is going to promise that there's going to be 6% economic growth next year so long as you elect me. Whether or not that is true is completely irrelevant to the bullshitter. It's probably not true, but you can't really prove that it isn't. And all it does is beat you down the road a little bit. Public relations specialists, another example of bullshitters. And although Harry Frankfurt did not mention them, I think lawyers are really good examples of bullshitters as well. So the thesis to my paper is not really about bullshit so much, but it's really about in-house counsel. I think in-house tribal counsel have a unique vulnerability to bullshit, largely communicated by outside counsel to the tribal client. Okay, so you might get that reading between the lines and look at the title. But there is a sub-thesis here which does directly relate to the Supreme Court, which is in-house counsel, I believe, is a very critical gatekeeper to Supreme Court litigation involving tribal interests. A lot of these cases, not all of them, maybe not even a majority, but a good chunk of the cases that go to the Supreme Court start out in the in-house attorney's office. And I personally, working in-house for 4 different tribes, saw some of these cases. None of the cases I worked on went to the Supreme Court, and I'm not going to take credit for somehow making sure that they didn't go to the Supreme Court for somebody to lose. But a lot of cases arose that I thought, looking back, because I was a young attorney when I was in-house, but looking back, I thought some of these cases had a very significant potential to go to the Supreme Court. I'm glad they didn't, frankly. And for whatever reason, they were often derailed into other things or settled or whatever happens. But I think in-house counsel is far more important than we give them credit for assessing these cases in the first instance. All right, so to give you down sort of the basic paradigm what I'm talking about, now I'm going to talk about beta mills. So what I'm going to do is give you a timeline. And at some point in the timeline, I'm going to stop and say, from here on out, I'm just speculating. I'm not trying to bullshit you at this point, but it may sound like that. So I'm telling you right now, the first half of this timeline is material that I've gathered from legal pleadings, court cases, and news reports. And there is a lot of bullshit in there, maybe, but I'm really going to focus on what I think are pretty reasonable facts that people generally agree with. So let's start at the very beginning of the dispute in the Bay Mills case. Bay Mills buys land in Vanderbilt, Michigan, which also has a building on it. It used to be a rest area. And it issues a press release and is quoted in the paper, or excuse me, not is quoted. Tribal leaders, the tribal chairman, Jeffrey Parker, is quoted in the newspaper as saying this is for elk hunting. This is off-reservation elk hunting within the ceded area of the 1836 Treaty of Washington. It's part of the inland settlement in the 2007 United States versus Michigan consent decree. And my sense is from the moment that this press release is issued that Indian country in Michigan believed it probably was either an outright lie or bullshit, because Bay Mills had spent the last 10, 12 years trying to buy land in Vanderbilt for the express purpose of opening a casino. So when they did buy land in Vanderbilt, it had a small chunk of land with a little building on it. I don't know why you needed a building like that for elk hunting purposes, but perhaps they did have it. But they had, for a couple of months, political cover. Number 2, Bay Mills opens a casino, of course, within this building. About 50 or 60 slot machines, tiny little thing. They changed their elk hunting story to say, well, now we have demonstrated a traditional connection to this chunk of land because we've used it as tribal members for our elk hunting purposes. And they date their elk hunting connection to this area to about 10 years. Now, mind you, I got to stop right here and interject my own bias, which is very, very strong. If you, for whatever reason, are driving on I-75 north into upper Michigan, and you wanted to turn left to go gaming at the Little Traverse Bay Banzo-Odawa Casino, you would turn left at Vanderbilt. And that's exactly why Bay Mills has been pitching Vanderbilt as an off-reservation casino market opportunity for themselves, is to cut off Little Traverse. They've litigated off and on over the years with each other over Little Traverse's casino. And Bay Mills has fought gaming market opportunities in court with the Sault Ste. Marie tribe as well, which is closely related to Bay Mills in the Upper Peninsula. So I openly admit that I have a bias when it comes to anybody opening a casino on Little Traverse doorstep. And if you read some of the pleadings that Little Traverse filed, asking for an injunction in this case, you can see how fairly devastating it was to have 50 slot machines over on I-75, cutting them off from that market. It doesn't seem like a lot, but believe me, the 2 or 3 dozen people that Little Traverse had to shit can because of the market decline, those people were affected, certainly. Let's talk about the legal strategy that Bay Mills has. Their core strategy is based on something called the Michigan Indian Land Claims Settlement Act. And I'm not going to tell you that's bullshit. You could easily pass a Rule 19 motion by claiming this legal theory, and I'm not really even going to go to legal theory. It's not particularly strong. Its chances of prevailing, especially in a federal judiciary that's a bit skeptical of tribal interests, is pretty weak. And the statute itself really doesn't go as far as Bay Mills would like it to go, at least objectively. So that's their legal strategy, based on NALSA. But they have a backup legal strategy, and that backup legal strategy is got really two prongs to it. And the first prong is sovereign immunity. Nobody can stop us from opening a casino. We have a casino. The only entity in the world that can stop us is the United States. We are immune from suit from the state of Michigan. We're immune from suit from Little Traverse. We're immune from suit from any private entity that wants to challenge us. We have sovereign immunity. And they get the federal government out of this case by arguing for a narrow interpretation of the Indian Gaming Regulatory Act, and as well as the 1993 gaming compacts that Bay Mills is a party to. This is also a passable legal theory. And if anybody follows Supreme Court or tribal interest litigation, you know it's incredibly dangerous. This is putting out something that is very carefully controlled and cultivated by tribal interests around the country, and that is off-reservation sovereign immunity. So this is putting it out right there, saying if this is a venue or a vehicle for ending off-reservation sovereign immunity, opening a casino 150 miles away from your reservation is probably a good bet. So this is a dangerous legal theory. Now keep in mind, this is my fifth point in the timeline. Bay Mills has a reasonable goal here. I believe it is an off-reservation goal. They want to open a casino in Port Huron, Michigan, which is on the border. It's near the Detroit River on the other side of Sarnia. There's a casino on the Canadian side that the state of Michigan hates because everybody goes gaming over there when they could be gaming in Michigan. Michigan, the state, the last several governors, frankly, have cut deals with tribes like Bay Mills to put a casino there. They haven't been able to get past the federal and or congressional hurdle, so it hasn't really gone anywhere. They openly admit they want to open a casino in Fort Huron. I'm for it. Go for it. Go far away from Vanderbilt. That's where all the money is. They're not making any money in Vanderbilt. The only entity that they're affecting is Little Traverse. So why do they open in Vanderbilt instead of Port Huron? All I can say is, All right. Number 6 on my timeline, Michigan and Little Traverse, in the reverse order, excuse me. Little Traverse and Michigan sue. The United States doesn't do anything. We have a great friend who works in the United States Attorney's Office for the Eastern District. She handles civil tort claims, and once told me a couple of years back how many phone calls she got from tribal attorneys up north saying, when are you guys going to intervene in this case and shut down this casino? Because it was open for about 6 or 8 months. And her response was, if a postal worker commits a tort on the reservation or the casino property, I'll be there the next day. And that was her jurisdiction. All right, so enough of that. Around that time, the Department of Interior and the NIGC issue opinions on Bay Mills legal theory. And the Milska legal theory, they don't buy for a second. They think it's baloney. They reject it completely. They hold as an agency opinion, 2 agency opinions, really, that this is not Indian lands under the Indian Gaming Regulatory Act. You're not supposed to be gaming there. But the NIGC also argues that, why are people calling me? Especially since I have a rule that if it comes from area code 918, I don't answer the phone. All right. What was I talking about? All right, so the NAGC issues an opinion also saying, since this is so far afield from our jurisdiction, we only deal with on-reservation gaming issues, this is so far off reservation, we don't actually have jurisdiction to do anything about it, which is a bit ironic because there's a half a dozen opinions on their website where they say, well, this isn't on Indian land, so we can shut it down. But they won't shut this one down. I think they were trying to help Bay Mills. So, all right, that moves us to number 8 on the timeline, which is eventually Bay Mills wins in the 6th Circuit. And number 9 is, of course, the Supreme Court's going to grant cert in this case. Now, keep in mind, this was not inevitable. There are a lot of things that could have stopped this from ever happening. NIGC could have said something. They could have taken action, issued a notice of violation. Even if they had lost on the jurisdictional issue, it would have probably been litigated through that avenue rather than through what Bay Mills argued in the Sixth Circuit, which was we're immune from suit from the state of Michigan and Little Traverse, and you can't touch us. They won that. They won that argument in the Sixth Circuit because that actually is Supreme Court precedent. They do have immunity from suit off the reservation. So the other thing I think that's important to know at this point is that at this moment, until after the Supreme Court grants cert, Bay Mills has been litigating this case using in-house counsel. That's unusual. Occasionally you'll hear about cases argued in the federal appellate courts involving tribal interests that are argued by in-house counsel. But in the last 10 years or so, that's gone away. Tribes have more capacity to hire appellate specialists, and they tend to do so. Bay Mills doesn't really have that capacity, and that's fair enough. But they don't have a lot of money, and I don't think anybody disagrees with that. So they stuck with in-house counsel. I think it was a little bit of a vanity thing, but that's just me. Maybe that's bullshit. All right, so around the time that the Supreme Court grants cert, finally Bay Mills hires Supreme Court specialist. And now this is where I have to say, look, from here on out it's speculation. I've heard a lot of things. It's all rumor. I don't know. I have no idea. It's not in a legal pleading, and it's not in the news. And some of it I've changed, really, to fit my thesis. So this is not intended to be any kind of reporting of facts, but merely a hypothetical. But it is based on what I've heard. And there are really three things going on here. Number one is the Tribal Supreme Court Project, much like Bethany talked about, has asked the Bay Mills Indian community to waive its immunity. A few years ago, the Oneida Indian Nation was in a similar position in that there was an immunity case where they were the winners in the Second Circuit, and the Supreme Court granted cert. And so they decided to waive their immunity. And luckily, the Supreme Court decided to do a GVR, where they would remand the case back down to the Second Circuit to reconsider the case in light of the waiver of immunity. So they mooted the case. When I say the Tribal Supreme Court Project, I mean the Native American Rights Fund and the National Congress of American Indians. I'm told, I don't know if this is true, but 5 times members of one or the other went to Brimley, Michigan in the Upper Peninsula. I don't even like going up there. To ask them to waive immunity, to try to make this case go away. Now, yeah, it's not a guarantee. It's a possibility the Supreme Court will continue forward with the case, and there are other reasons why the court would continue to do it, but at least it would have been an effort. And what happens next is kind of interesting. Each of the 5 times, the Bay Mills Tribal Council, allegedly, calls up its Supreme Court counsel, its specialist, and says, you know, they really want us to waive immunity. What would happen? And the response almost invariably was, I shouldn't say almost, I don't really know. The response was, I won the Guantanamo Bay case, I won Obamacare case, I'm going to win your case for you. I'm guaranteed you will win. All right, that's bullshit area number 1. Number 2, the Tribal Supreme Court Project asked the National Indian Gaming Commission and the Office of Solicitor General to intervene in this case, to take jurisdiction over this matter, and try to moot it that way. And it turns out, as my understanding, is the NIGC, finally realizing the error of its ways, says, yeah, we played a good game for a while, but yeah, we're going to take jurisdiction over this case because nobody wants the Supreme Court to handle this sovereign immunity issue. But it's too late. The SG trumps the NIGC and says, no, you don't play games with the Supreme Court. Maybe Oneida got away with it, but we're not going to be able to do that again. And we're going to litigate this to the end. And by the way, they guarantee the win. The SG guarantees the win. So that's the bullshit area number 2. And number 3, I don't know if this is really a bullshit area, but this is the third part. And this stuff is so fantastical, you can't make this up. Even though I'm telling you right now, I don't know if it's true. Maybe it is. So Bay Mills tribal members call a special meeting with the General Counsel. Now some tribes, not all, have a provision that they will basically govern through direct democracy. Everybody who shows up to a particular tribal meeting that's called correctly can vote on a big issue of tribal governance. And so they decide to have a meeting on whether or not to do what the Tribal Supreme Court Project is asking them to do, which is waive immunity. And they have a big presentation about the merits and demerits of proceeding with this case. And tribal leaders give a great presentation that effectively defeats this movement. And they equate the waiver of tribal sovereign immunity to the waiver of the tribe's sovereignty. If this is the case, this is bullshit. A waiver of sovereign immunity in any given case, or a contract, or any matter, is not the equivalent of, deinstitutionalizing the tribe, or waiving the tribe's sovereignty, like it will no longer be a sovereign entity. But they make that argument. And the second argument they make is that the people who have brought this forth, the tribal members who have called this meeting, have some sort of financial interest in against Bay Mills, and so therefore they had, they allege all sorts of financial conflicts of interest. I don't know if they have either. It's whatever. So all of this stuff is just tribal politics, which is a good part of my paper: tribal politics and bullshit. Politicians are politicians. So that's the third area. The case is argued. There's a lot of baloney in the case as well. I think that's a separate paper. I'd love to talk about oral arguments and bullshit representations to the court. But my thesis really is about in-house counsel. And in-house counsel is very vulnerable to this kind of action. So first of all, as I've already said, I think that in-house counsel is terribly critical to heading off or managing a lot of these cases that can go to the Supreme Court. But I think that in-house counsel should be obligated, and should know that they should be obligated, to be aware of a given case on the ground, to really give a good sense of whether it's a winner or a loser. And so, for example, I remember a case, it never became a case, but it was an issue having to do with a Xerox copier machine that we leased in the legal department at Grand Traverse Bank. We got a bill from Xerox saying, well, you have to pay $75 a month to Suttons Bay Township because they have a personal property tax, and they're charging us, so we're passing it on to you. And it just, oh man, grind your gears. We didn't use that thing for anything but internal tribal government stuff. This is the core efforts of the tribal government. And what are you going to do about this? You're going to take it to the Sixth Circuit? We probably could have won. I mean, the Sixth Circuit really isn't half bad. I mean, they let Bay Mills win. So we could have won that case. But what would be the point? What would we win? $75 a week? Or excuse me, $75 a month? Or potentially a Supreme Court grant, and then have to fight in front of the Supreme Court over whether or not a county can, or a township, can issue impose a personal property tax on internal aspects of tribal governance. I guarantee the answer is going to be no. The tribe doesn't need to have that exemption. So these are little things that can balloon into much bigger cases. And I think that in-house counsel also should be obligated and educated to learn what kind of cases are potentially circulated. There are some cases that tribes can win, frankly, if they are managed properly, and you figure out a way to keep them out of the Supreme Court. And some of the good treaty cases tend to be winners that don't get to the Supreme Court because they're narrow, and they're limited to just one treaty or just one small group of tribes. But the vulnerability goes like this. In-house counsel is vulnerable to tribal politics. They don't have the same protections that state and federal government attorneys have. They're going to be shit-canned. A lot of them, a lot of in-house counsel fear they will be fired if they disagree with tribal government, or if they do something that tribal council members, tribal chairman, whatever, disagree with. They are inundated by tribal politics. Every given day in an in-house counsel's office, tribal members can show up, tribal council members can show up, and lobby them to take all sorts of action. This is not a real good way of doing, of having useful and effective a legal department in-house with Indian tribes. Secondly, in-house counsel is disadvantaged by many of the advantages that outside counsel has. Outside counsel are specialists. So in-house counsel is a generalist. So a tax specialist can say, well, you might have this view generally in all these cases, but we think we can win on this issue. In-house counsel is often hamstrung by the inability to really push back on some of these representations by outside counsel. There's questions of paper credentials. Outside counsel works for big firms. They all went to Stanford and clerk on the Ninth Circuit. Occasionally, I've seen this as well, outside counsel is white, in-house counsel is person of color. And that matters sometimes. Maybe not as much as it once did, but it does matter on occasion. And last, of course, that law firms always overwhelmingly have a profit motive. I'm trying to find any kind of evidence whatsoever that for-profit law firms really do things because they just love tribes. I'm still waiting for that stuff. And the last part really is that outside counsel can employ bullshit to just remarkable levels. They will tell in-house the tribal leaders that in 5 years you're going to have that casino open and you're going to be making $1 billion a year. That we're going to get this land into trust in a couple of years. All you got to do is give each member of the congressional delegation and the Republican side $75,000 and we'll get that land into trust. or of course they'll guarantee a win in the Supreme Court. So my last points are just going to talk about what I think is a way to push back, and a lot of it's education, getting in-house counsel to know about Supreme Court practice, about appellate litigation practice, more so than they often do now. I think that in-house counsel should begin really expanding the an in-house counsel bar association. There is one, but in-house counsel is busy. They don't always have the chance to meet a lot. Fed Bar is not an in-house counsel association. Fed Bar is a place for solicitation for clients as well. So they need to have a separate thing. And agenda item number 1 really is figure out a way to push back on how to guarantee, to provide some institutional and employment protections to in-house counsel so that they're not as uniquely vulnerable. And the last thing is, I think we need to rethink what sovereignty means in a lot of ways. And I'll leave it at that because, hey, that's on the problem. Thanks.
Matthew, and we're hoping to have some time for questions, so because I raised a whole bunch of questions in my mind. But let's move on to Kristen Carpenter, and who is an associate professor of law and co-director of the American Indian Law Program at the University of Colorado Law School. And it sounds like Kristen's going to give us a little bit more upbeat, but we'll see. And then afterwards, hopefully people will stick. We're running a little late, but we'll open it up to questions and.
So remind me when we want to end this panel just so I can adjust on the clock.
We have 10:45 as the time, but we started late, so if people are willing to push it out a little bit.
Okay, great. Thank you. Good morning, and thanks so much to all of you for being here. Especially congratulations to Stanford NALSA for putting on a terrific event. And I'm honored to be here with Nikki and some of my closest friends and colleagues here on the panel and in the audience. My talk is entitled American Indians, Living Cultures, and the Roberts Court. And in it I'm trying to offer a reflective approach that considers some of the decisions and their aftermath through the lens of tribal culture, or more particularly through living cultures. And I should be clear that I'm not offering a doctrinal analysis of the decisions or suggesting better strategy, and I think we've heard some great points along those lines, but trying to think about what the cases mean now that we're about a decade into the Roberts Court, and offer some theoretical and contextual observations through the lens of culture. So as many scholars have noticed and observed, law and culture are deeply and mutually constitutive. So the decisions that the U.S. Supreme Court makes in Indian law reflect and implicate culture. Indian culture, non-Indian culture, and everything in between. Yet these aspects are not always readily apparent in the decisions themselves. And so in some of the cases that Bethany and Matthew have touched on, Plains Commerce, right, the court describes it as narrowing the federal common law rules of tribal court jurisdiction. In the adoptive couple case, it's about narrowly interpreting a federal statute. But when those cases come to Indian country, they look and they feel, and they really are different to the people that are most deeply affected by them. And of course, this is true along many dimensions. We could talk about power, wealth, and legitimacy when we're talking about Indians in the Supreme Court. But the issue I want to deal with is culture. Matthew started his talk with some definitions, and I'll try to do the same. I think the term culture is used colloquially often by Indian people to describe the lifeways that are important to them as tribal peoples. But the term culture is complex and it's contested, especially, of course, by academics. One law and culture scholar argues that culture serves as a reference to a particular way of life by and through which a group of people who share common characteristics, such as ethnicity, religion, language, or history, express shared behavior and values. I think this definition is helpful in a sense, to the extent that it transcends some of the more classic definitions from cultural anthropology that, for example, describe culture as the sum total ways of living built up by a group of human beings transmitted from one generation to another. This idea that culture could be neatly accumulated by a particular group, summed up and passed along unchanged along generations, has inspired challenges of romantic essentialism from numerous quarters. In my work with Professor Angela Riley, who you'll hear from at lunchtime, we have a number of projects together. You'll probably hear us referring to several of them. But in one of them, begun to examine the myth of cultural cohesion by looking at a number of scholars who are focused on the idea. So Adam Cooper's work in anthropology, Elvira Politano in literature, Karen Engel in human rights. And we see all of them expressing a collective concern about the pressure for indigenous peoples to adopt certain indices and expressions of authenticity that limit their choices and autonomy in the contemporary era. And when I was listening to Matthew, I was thinking about how another set of concerns might be, from some quarters, how certain indigenous expressions of authenticity might mask tribal claims in the modern era. And the story about the hunting lodge turned casino might raise some of those thoughts. So when you think about all of these points about culture, I'm mindful of the point that Sam Deloria made a long time ago, that it's not in the interest of tribal governments to tie their claims too closely to cultural preservation. Tribal governments are governments. Other governments don't have to base their claims on certain expectations of a static culture, and the same should be true of Indian tribes. But Sam also said in the same quote that tribal governments do have a responsibility to consider the impact of various possible public policies on the culture of their people. So even while tribes can be too tied to particular notions of culture, they do have particular and serious responsibilities along those lines. And he describes tribal governments as the conservators of cultures that are threatened on a daily basis. So tribes are working some pretty fine lines, and again, my work with Angela, we're interested in unpacking that notion of cultural conservation or preservation as it appears in some of these cases. There's a provocative new book that I've been reading by Joanne Barker, arguing that tribal people should be wary of what constitutes a culturally authentic native status. She takes on some of the most hotly contested lines of identity and culture, including enrollment, gender, sexual orientation, and so on, to argue that Native people should heal from their own privileging of what she calls the recognizable, enrollable, traditional, full-blood male Indian. So she's arguing for a paradigm of decolonization when it comes to culture, and writing further that Native cultures are not merely what they are, the way they are defined in U.S. national narrations. People need to re-articulate their own culture in a way that would be meaningful today. So when we look at the Supreme Court, that's kind of what I'm trying to do. How do Indians begin to confront the narrations about their culture that are coming out of the court? And for the remainder of the talk, I'll more closely hew to the decisions from the court. So when we look at some of the ones from Bethany's list, I think that one of the things that's really interesting about these decisions is that many of them touch on, but perhaps not in a really explicit way, some of the elements of Native culture that are the most sensitive and deeply felt in Native communities. Two of those elements that I'm thinking about are land and kinship. So some of the definitions that I think are meaningful about indigenous peoples and culture have to do with particular tribes' relationship to a land base, perhaps coming from an origin story more contemporarily, a territory where jurisdiction is maintained, and the people's relationships with one another on that land base, comprising what it means to be Cherokee or Navajo or another tribe today. When you look back at that list, again, it's interesting to see several cases in the land and jurisdiction context, and I'll start with those. So going back to 2005, a case, again, ostensibly about tribal jurisdiction, the Plain Commerce case, recall that there the Long family, who were longtime ranchers at Cheyenne River Sioux, had borrowed money from the Plain Commerce Bank to support their ranching operation. There were a few bad winters. They lost, I think, 500 cattle and tried to refinance the loans that were allowing them to continue the ranching operation. The bank refused and then foreclosed on their property and sold it to somebody else, non-Indians, on more favorable terms. And the record revealed all these discriminatory comments about lending to Indians. So the Long family sued in tribal court for discrimination in lending. The tribal court, as well as the federal district court and the 8th Circuit, all found that the tribal court appropriately had jurisdiction over the case. But the U.S. Supreme Court, Chief Justice Roberts, reversed on grounds that the court lacked jurisdiction under the Montana test. This is a case that you all know well at this point, so I'll do it quickly. The probative point for me with respect to this conversation is that Chief Justice Roberts said, as his reason suggests not applying was as follows. The sale of formerly Indian-owned fee land to a third party is quite possibly disappointing to the tribe, but cannot fairly be called catastrophic for tribal self-government. So there was no jurisdiction under Montana's second prong. The court also said that land that had been owned by a non-Indian for 50 years, in that case it's transferred to another non-Indian, couldn't imperil the existence of the tribe. Roberts was talking about land within the tribe's aboriginal territory, reserved by treaty, located on the reservation, and it's probably safe to say that after hundreds of years of fighting to maintain a tribal land base, every acre within the reservation boundaries is critical to the tribal existence. But looking even more particularly at those facts, the family there had ranched for generations, pursuing a livelihood that enabled them to connect in meaningful, contemporary terms, a way of life to the land. The non-Indian involved was the dad of an Indian, a tribal member, and he was married to an Indian, somebody who was deeply related to the community by kinship. And of course, this land was integral to the family on it, and being able to have their case heard in tribal court was arguably integral and important to the culture of the tribe. More recently, as Matthew was saying, the court has heard a series of cases dealing with Eastern land claims, a lot of them coming out of the First and Second Circuit. In the Carcieri case, Bethany alluded to this too, the court held that the Secretary of the Interior didn't have authority to take into trust lands reacquired by the Narragansett tribe on grounds that the tribe wasn't under federal supervision at the time of the Indian Reorganization Act in 1934. So whereas Claims Commerce took a narrow view of federal Indian common law with respect to jurisdiction, Carcieri did the same with respect to a federal statute designed to help tribes recover their land bases, following all of the policies that we know that have reduced those land bases. And then finally, in the Madison County versus Oneida case, the court almost heard a case about the Oneida Nation sovereign immunity with respect to newly acquired lands. But to avoid that judgment, as Matthew said, the tribe essentially holds the case. So in the Roberts Court, tribes are losing jurisdiction over Indian lands, and they're even losing the opportunity to recover lands as Indian country, whether on the open market or through the federal process designed for that. And the question I wish to pose is how, through the lens of tribal culture, are tribes dealing with those decisions? I mean, I'm supposed to be optimistic, so that's what I'm working towards here. So just a few examples, and I'll do the same with the kinship points and then wrap up. So within tribal communities, there is a lot of attention devoted to land recovery and culture. And you could survey the country, and of course different regions have different particular issues. So we might be dealing with the failure of recognition or allotment or the loss of reservation land base. But if you look at tribal constitutions drafted recently, and I love the constitution of the Yurok tribe, there's a tribal member here to tell me if I'm getting it wrong. But I was reading it just recently, and it states as two of its 5 or 6 governing purposes. One, the purpose of the Yurok tribe is to preserve and promote our culture, language, and religious beliefs, and to pass them on to our children and grandchildren, and their grandchildren forever. And in the very next sentence, to reclaim the tribal land base within the Yurok reservation and enlarge the reservation boundaries to the maximum extent possible within ancestral lands of our tribe or with any compensatory land area. If you survey the hundreds of tribal constitutions, they don't all have language along these lines, but many of them do reaffirm the connection to land, in particular tribal terms. The Yurok Constitution goes on and on with really beautiful narrations of Yurok culture. And so I think that it's the case that tribes remain determined to recover their land bases, whether through open market or other approaches, and they haven't been convinced by the narrative of the court that it's too late, or as Matthew's arguing elsewhere, too disruptive to do so. But the question remains, if they can accrue the resources through gaming or through oil and gas or otherwise to reacquire those lands, how are they going to get jurisdiction back? And their tribes and their lobbyists, as we know, and there are folks here in the room who know this much better than I do, are trying to architect a fix to the Carcieri opinion, Hatchak, and so on. I think the latest attempt at that just failed this week, essentially. But there is a good amount of leadership, and probably leadership in this room, that aims to repair the remedial process for reasserting tribal jurisdiction over reacquired lands. looking at the New York and Eastern land claims as another example, it's unclear to me when and if New York will ever settle those land claims with the United States involved. Of course, I hope they do. I hope it's with broad economic and political ramifications, disruptive or not, for all. But in the meantime, one of the examples I like to hold out in the face of all of these land claims that have essentially gone to hell is the example of the Onondaga Nation. I know, positive. The Onondaga Nation, which has really been a leader in framing its claims to acknowledge relationships with the surrounding and close-by community, drawn on the two-row wampum, the conception of their neighbors as partners, as long-term residents, and their common interest in cleaning up Onondaga Lake. In every one of their complaints, in negotiations with their neighbors, they've articulated the shared application of the land, the desire to improve the environment for everybody there. There is an organization called Neighbors for the Onondaga Nation, NOON, that bring together tribal members and non-members for meetings and for advocacy in favor of some of those environmental cleanup projects. And I think there's an example that, okay, the settlement of New York land claims may well take forever, but the tribe isn't waiting, and it's also insisting on driving on its own cultural norms in a way to go forward to the important aspect of land recovery, and land recovery in a way that involves its neighbors, right, as kin, as relationships that are important to them. I realize you've all been sitting here for a while, so I'll try to talk about the other aspect of all of this, the kinship aspect, again, through the adoptive couple example. We've heard a great deal about the adoptive couple versus baby girl case from Bethany. You really nicely summarized the case there. What I'll add from the lens of culture is that in addition to being well cared for by her parents and her grandparents, baby girl was a Cherokee child in every sense that matters from a contemporary cultural perspective. She was, as Bethany says, living in the Cherokee Nation, but she was also participating in all of the aspects of life that a Cherokee child would participate in today. And I think it's important to notice that can mean a whole bunch of things for a whole bunch of different people. For baby girl, and I will say I've worked with her attorney enough to be sensitive to the privacy issues and to try to maintain that. But she, and I happened to be there at the time, baby girl was there at the grand entry for the Cherokee Nation powwow on August 30th or 31st, right before she was taken away. She was wearing a tiny little purple shawl. She was holding each hand of her stepmom and her dad. She was dancing behind the tribal chief. And she was there quite literally in the circle, surrounded by tribal members, surrounded by all of us in the audience, surrounded by Cherokee territory. Outside of that, she was just deeply immersed, grounded, protected there. And then all the light flashes went off and she was whisked away. That was that. But at the same time, she was celebrating her 4th birthday on tribal land in a Disney princess party, right? She was living with a normal little Cherokee girl in the Cherokee community, and all of that is what it means to be a tribal child today. She was deeply embraced by the people from all walks of life in the community. There's a video that I just love where different Cherokees were interviewed in Cherokee to describe her, and all of them said, baby girl, she's our girl, keep her home. Again, kinship in land, right? She's our child, we're claiming her, let's keep her here in the community. So what to do in a case like this where the cultural elements of an Indigenous child's relationship with her family and her community are completely distorted, as Bethany says, by the court, where everybody's hearts are probably still too broken to figure out what to do about it. But of course, everybody has to pick up and move on. In that case, following the Supreme Court's decision, the tribally appointed attorney for baby girl, along with NICWA and NCAI, decided shortly after South Carolina put out an arrest warrant for her dad to make a human rights claim to the United Nations. And I, with some other attorneys, worked on it. And we've actually just received permission to share that document, so it'll be coming out pretty soon. But the attorney for baby girls felt that her voice was not being heard, and particularly her interests as an Indian child, which involved the human right to culture, were not coming out in the conversation so far. Interestingly, and Bethany alluded to this too, although U.S. Law and U.S. doctrine provides very few protections for culture per se, international human rights law has culture all over the place. And so in the UN Declaration on the Rights of Indigenous Peoples, and I won't go through all of the articles, I promise, but Article 8 provides that Indigenous peoples shall not be subjected to forced assimilation or destruction of culture. Article 9 provides that Indigenous peoples have the right to live with their community or nation in accordance with the traditions and customs of that nation. Moving on to Article 27 of the International Covenant on Civil and Political Rights, there's protection for an individual's right in community with the other members of their group to enjoy their own culture, to profess and practice their religion. Finally, the Convention on the Rights of the Child, which the U.S. isn't a party to, but everyone else is, recognizes that no Indigenous child shall be denied the right in community with other members to enjoy his or her own culture, and there's a lot of language in the notes to that convention that speaks directly to the risks of removing children from their Indigenous cultures. The UN Special Rapporteur, if you were following the news, did issue a statement about the importance of U.S. courts providing process for a baby girl to have her best interests adjudicated in a way that would pay attention to her human rights as an Indigenous child to participate in her Indigenous culture. The report was widely covered in the news media, but as we know from Bethany, baby girl was removed anyway. So a question to ask at this point, again trying to be positive but realistic, is whether the human rights advocacy does offer a meaningful avenue, whether it makes any kind of difference. The lawyers that I've been working with in that context keep trying to remind me that it is a long struggle. The Indigenous peoples have been using international processes for generations, that we can't give up, even when in the face of all of this difficulty. I will note that just this week, some of the organizations that were involved with our submission to the UN Special Rapporteur, so NICWA, National Congress for American Indians, along with some others, delivered a letter to the Department of Justice asking it to investigate child welfare, custody, and other proceedings in the United States, evoking some of the language that we had in the petition. And I'm hoping that some of the usual points of contact, so the U.S. government hearing not only from the Human Rights Mission in Geneva, but also internally from NGOs, will start to move this process forward in the United States, such that investigation will not only look at ICWA compliance, but look at ICWA compliance in a way that's reflective of some of the cultural norms that are so important here. I'll also note that this month and just a couple of days ago, the Cherokee Nation amended its own child custody laws to prioritize the role of the biological family and extended family members in raising children. The Tribal Council's resolution states every Cherokee child has a right to be raised in a home that embraces their unique cultural heritage. And this amendment complements a full panoply of child services, foster care, dependency, neglect, other services that are offered by the Cherokee Nation. And I think that there are many tribes that are working incredibly hard on their infrastructure through tribal governments to develop programs that really meaningfully protect children in their communities. Matthew and Winona have a chapter in their book about the Indian Child Welfare Act. It's authored by Terry Cross and Bob Miller, that looks at tribal governments' approaches to child welfare issues. The Harvard Project on American Indian Economic Development also has a series of case studies that I think are really revealing in that way. And for me, what's interesting about all of this is that I think it's pushing back on a narrative in many quarters that the best interest of the child is somehow separate from the best interests of the family and the tribe. And I think that, even speaking generalities, is really a distortion of any tribal cultural approach to children and to family, in which the well-being of the child has always been at the center of what people are thinking about and trying to strive for. To, I guess, try to bring this all together, if we're thinking about living in tribal cultures, we're thinking about law that provides little inroads, and perhaps tribal law and international human rights law most powerfully, tribes need to continue to articulate what tribal culture means course as we go forward.
Thank you, Kristen. I think we're going to open it up for a few minutes of comments. So do we want people to speak into the mic for recording purposes, or do we? Yeah, just so we can get it.
All right, I have just a couple of questions. Bethany, I thought in the adopted couple case, I was curious what you thought were about Breyer's vote. And I looked back at his concurrence, the reports to the limit, the majority opinion, and then I think back to Racing Cayetano, when he said, well, we're not going to consider these Native Hawaiians as tribal groups because these people can be 1/500 Native Hawaiian and qualify as a Native Hawaiian under this definition, and that's way too broad. And so, what do you think about it?
Yeah, so Breyer's vote on Breyer's concurrence, the thing about it, it was a concurrence in the opinion, not just the judgment. And everything he said was pretty, maybe this could mean this. He didn't actually say this could mean this. So there was a great dissent by Justice Sotomayor that said, this means, basically what the Supreme Court said, if you don't have legal custody of the child at the time it's filed, you don't have rights as a birth father. And unmarried fathers just about never have legal custody of the child. And he said, well, maybe if they were paying child support and stuff like that, at least that would give them rights under state law. It doesn't look like, that's not what the majority opinion said. And Justice Breyer said, I'm just suggesting, I'm not expressing an opinion on it here, that maybe the birth father could enter the placement preferences again by formally applying to adopt his own child before the case is decided. And he was just kind of like, maybe, I don't know, just spitballing. And the South Carolina Supreme Court obviously didn't pay attention to that at all. So it's not as strong a negative concurrence as you want. And yeah, I find it so fascinating. Breyer's concurrence in Rice v. Cayetano said, well, maybe you could have these special voting rights for Native Hawaiians if they were just a little bit more biologically Native Hawaiian. So, groups of lineal descent from around 1900, that's enough. But this is lineal descent from 1778. So that is very much tied into that, race counts, but it has to be a lot of race logic. I hope Breyer has advanced a bit since then, in 2001.
Yeah.
But I don't know what was going on, why he joined really the majority opinion there. He looks like he could have been the swing vote.
I'm trying to bring the mic around just to make sure that it's on.
Carol Goldberg. Great panel. Just one question for Bethany and Kristen, and then one for Matthew. The one for Bethany and Kristen is, what I was hearing was that you, Bethany, were calling into question the thesis that David Gittis had suggested, that trying to appeal to more mainstream values would be a success route for tribal advocates in the Supreme Court. And what I'm hearing you say, that, Kristen, is that same kind of critique, that is advancing a counter-narrative of tribal culture and the centrality of land and kinship and so on, is the strategy perhaps for greater success, at least trying to counter that narrative. Is that where you're both going, or is it in some other direction? So that's my question for the two of you. My question for Matthew is just sheer propagation. Because I was hearing you talk about all the ways in which various entities were approaching Bay Mills, about perhaps
averting the Supreme Court review. And the one I didn't hear was intertribal direct negotiation, which just kind of in the back of my mind sounds like maybe it would have been the one avenue that most directly addressed what was stimulating the problem in the first place. And how might that influence the role of in-house counsel? So there we go.
Yes, you might have asked a question that's going to get controversy on the panel, because even though it's, or disagreement on the panel, even though it has not been all that successful, I think it still is the way to go to try to appeal to something that the justices can understand better than they can understand Indian tribes. So if you look at U.S. v. Lara, I think that the attorneys did a great job in trying to speak about this as not just a specially Indian issue, but as the relationship that the federal government has with all kinds of sovereigns that are not states or the federal government. And I think that even issues that are distinctly cultural issues, issues about land, about kinship, as Chris had talked about, we can describe these in ways that anybody can understand. And we have to do this. We can't, as I heard one professor say, we just have to explain that equal protection in Indian cases is different. That, they're not going to buy that. They don't like equal protection in non-Indian cases. And so like an even more special thing, it's just not going to work. So even though we're still losing now, we've got to keep making those arguments. And the sad thing is I can't say that we've been making those arguments poorly. But that's the only way to thread the needle, I think. And
So necessary but not sufficient?
yeah, necessary but not sufficient.
So, you probably always ask the best question, so thank you. And I guess I'm going to say necessary but not sufficient or successful. So I've spent most of my, okay, there's the example, the exception. But, so most of my work, as you know, is about American Indian sacred sites. And I've spent a lot of time trying to argue that through religion, the First Amendment, and through property. And to minimal success, as you know, we trying to translate American Indian culture into, or other interests, right, into causes of action or doctrine, or even narrative that the U.S. Supreme Court can recognize, I think is a challenge. I might be feeling a little cynical, but at this particular minute, I don't even think it necessarily matters if we're doing it in, I don't want to preempt our lunchtime discussion, but Angela has some really very powerful thoughts here. I don't think that whether we're arguing on mainstream values or more particular Indian values, we seem to be making too much headway in court. And I thought about the adoptive couple in that way, and I started to write an article about, well, how could we sort of take the mainstream values approach to the adoptive couple framework, if not the case? Could we be arguing that, following decades of feminist theory, fathers and mothers should have more equal rights? Could we make some individual autonomy argument? Could we mobilize the Scalia sort of argument? And I sort of gave a few paragraphs into it, and maybe I'll go back to it to try to figure out whether, like I've tried to do in the sacred sites analysis, I can find some other category to argue for the kinship interests. And I guess all I'm saying here, and I'm making less of a strategic point than a descriptive point, is that in the shadow of the court, tribal people will keep living their cultures. And there are a number of examples of the ways in which they've done that. Of course, their freedom to do it is limited. If we're talking about law, and of course we're talking about law, I think tribal law and international human rights law perhaps offer a little bit more flexibility. But that's as far as I can go.
All right. I can answer both of those questions. So to answer the one that you asked me on a very micro level, there's just a simple failure of leadership. Downstate tribes don't want anybody, in their backyard, so they refuse to talk. I pitched an intertribal gaming compact between the 1993 tribes. It's in the 1993 compact. Section 9 says, when you offer reservation, negotiate amongst yourselves. Governor Engler didn't want anything to do with it, and he thought, probably rightfully, the tribes would never agree to offer reservation gaming and do revenue sharing amongst themselves. And so, you know, nothing really happened. But what an amazing opportunity for, this is what happens around the country. I wrote a blog post about it, and you would be shocked, I think. The responses I got were so horribly negative. But think about a pool of money that's available as a gaming market in any given state. The tribes have to give 10, 25, 8, 16.5%, whatever, to the state. And I think they can cut that in half by just agreeing amongst themselves that there's a whole gaming market, we're all going to share it, right? And we may have to divide it up based on our geographic locations, but there's no reason why Bay Mills and Sault Ste. Marie and Saginaw, Chippewa, and Nottawassa, Huron can't cut a deal. And they can totally corner the market just outside of Detroit. Now, the state of Michigan might not like that, and believe me, the congressional delegation out of Detroit might not like it, but there's no reason the tribes can't do that, other than just a simple failure of leadership. They refuse to do it. I pitched it to General Counsel at Saginaw, Chippewa, and totally nice guy, I love that guy, but he's like, that will never happen. We will fight to death to preserve our gaming market. And I think it is just fundamentally ridiculous. But to answer your second question, and this actually is going to lead up to the adoptive couple discussion. So, Winona pitched the International Human Rights Commission or treaty organization. The United States versus Washington tribes are talking about coming together to deal with all their internal issues through some sort of treaty negotiation. That is the future. That is going to happen. It's going to happen when Inhouse Counsel can make it happen. And they can help to influence and advise tribal leadership to make it happen, to stay out of federal and state courts, to stay out of the federal legislative process as much as they possibly can, and to govern themselves from within and with each other. And that is where so much of academic scholarship has failed, because it presumes that we can't dispense with the federal and state governments and the agencies as much as we possibly can. So many times I pitch an idea and they're like, well, the federal government will never let you do that. And that comes from Inhouse Counsel, that comes from tribal leadership. And I think what it is just you need some successes. And I think the VAWA pilot projects that were just announced the other day, where those 3 tribes are going to start prosecuting non-Indians, if they do a good job and they can defend themselves in federal court and show that they're actually doing a better job at guaranteeing criminal defendants' rights than state and federal courts are, they're going to win. They're going to win because they demonstrated what Angela called good native governance. They're going to win because they have the capacity to do so. And the other side of this comes back to the adoptive. I urge everyone in this room, if you care about this issue, to read the brief filed by the Casey Foundation, written by Patricia Millett, who now sits on the D.C. Circuit, or will as of February 28th. She wrote a brief basically saying ICWA is a best practices statute. Every state should have ICWA. And it isn't because of an Indian child welfare, because every kid and every family should have the protections of ICWA. It's an embarrassment to South Carolina, Oklahoma, all of the states in the Union to have such lousy child welfare statutes when ICWA is sitting right there and it only works for the benefit of Indian people. And that's what pisses people off, I think, is that they call it special rights for Indians. This is what the statute should be. And that brief lays out exactly how all these protections are going to work and how they should work for everybody in the U.S., not just Indians. So I thought the best argument is something that Kristen alluded to, which is the Cherokees provide all of this panoply of government services to Indian children and Indian families in need that state governments refuse to do. They cut those services. They demean them and belittle them, when in fact that's what every government should do in the United States. That is how tribes will win cases in the future in the Supreme Court, is by governing better than everybody else does. And that's not fair because we don't have any money, but we're going to keep working it. You know, tribes are timeless entities. We'll be around a lot longer than the state of Nebraska or the state of California. Trust me.
I have a question. What do you think the Justice Office's efforts to engage in a certain kind of conversation in concurrence in DC and benefit and engaging with them?
So it was interesting. So Justice Thomas concurred in U.S. v. Lara saying, hey, the need law is fundamentally at odds with itself. On one hand, it says tribes have sovereignty sovereignty. On the other hand, says federal government has plenary power. These two things can't make sense. It's an oxymoron. And a lot of us in Indian law have been saying, yeah, it's an oxymoron. How does this work? And some people are really excited. And I think, a lot of them were like, well, once he resolves that paradox, he's not going to resolve it in favor of Indian tribes. And basically, his concurrence in adoptive couple versus baby girl is like, yeah, what the heck, I'm concurring in this, not because of anything actually having to do with the case, but because I think that the paradox means that the Indian Commerce Clause doesn't give the federal government jurisdiction to do this, or a whole heck of a lot of other things. So I'm not one of the people that have argued for reducing federal government's Indian Commerce Clause power, at least when it comes to Indian tribes and Indian people dealing with non-Indians and non-native governments. But I think maybe there's some people on the panel that I know. Yeah. So maybe somebody else thinks there's more open. I bet you don't think there's more open Thomas's concurrence, but go ahead.
The only thing I'll say about Justice Thomas's concurrence is that he wrote the same exact concurrence in U.S. v. Lara. He was the only one who voted in that way, and second time around is the only one again. And I think I take that to heart. The dude is writing to law professors, and some law professors are listening. So adoptive couple has a lot more citations to law review articles. They released his concurrence stuff, but nobody cares about that stuff. I think he does, and I would hate for the Indian Commerce Clause to be squarely before the Supreme Court again. I don't know that it ever really has, so there's no reason to really push it. I don't think it has since Hagen, which is an embarrassment to constitutional law. But I don't think there's any threat there. What the threat is that there's 5 people who will vote for all sorts of things. They don't have anything to do with the Indian Commerce Clause.
What do you think is the Supreme Court to have a hard time thinking about things, or membership in tribes as a political kind of thing, as opposed to a racial thing? Just some other.
I'll say this, I think people have a really hard time talking about race generally. And I see it in law school faculties. Nobody wants to talk about race. If they talk about race, they put themselves in a position of being attacked for being too racial or not racial enough. And I think the Supreme Court thinks the same thing. So they are very tentative when it comes to race. I don't think they want, I don't think they think of Indian law as being a purely racial thing. I think that we're well within the parameters of it being political. And so you might hear the occasional snippet here and there. And, frankly, I think Bethany gives a little bit too much credence to the stuff that's said at oral argument or the stuff that's said in the concurrences about race. But really, adoptive couple to me, for all of its tragedy, is a simple statutory interpretation case. And the statute did not support Dustin Brown's position as well as it should have. I mean, maybe it was a mistake, and maybe there are some policy reasons that justify going in the opposite direction, but if the decision itself, if you carve away all of the extraneous stuff, is just a simple statutory interpretation case. It could have gone either way. Breyer voted the wrong way, and that's all we can say. I mean, the dude likes people to pretend that he's still a swing justice, right? He wants people to pay attention to him. So I think he throws weird votes into things every now and then so that people will try to remember who he is. He doesn't want to be the Scalia of the left. He wants to be in the middle like Kennedy is. So that's why he does stuff like this.
Yeah, so I think that the issue is that tribal citizenship is partly dependent on descent, just about every tribe. And that makes it hard to separate from race when you compare it to U.S. citizenship. And as I've argued, there are really good reasons that descent in a lot of cases is a necessary political criterion, given that Indian tribes don't have control over their borders anymore the way the U.S. tries to. Their populations have to go off reservation to get jobs and go to school, but that does make it an easier target.
I'll just add that the court is one thing, but I think also race is a relatively easy thing for advocates to manipulate. I was reading just the other day Professor Elizabeth Bartholet's opinion in the New York Times. She's a family law scholar and a transracial adoption advocate. She was my family law professor 19 years ago. I'm trying to say this in a constructive way.
Oh, just let it out.
She's not going to listen to this. She knows better. She knows that identity membership is not about race. And in the New York Times, she writes about the costs on children of delaying custodial placements for race matching. And she describes as the prime example of the Indian Child Welfare Act. And then describes children as resources of tribes and sort of diminishes that aspect. She was the lead author of